Scholar channel. Today I am going to tell you about the European Court of Human Rights judgment on the case of Loizidou versus Turkey, particularly why the judgment is important, the questions of facts and law. Just the essence, nothing else. To start with, the historical preconditions of this case are the internationally recognized occupation of northern Cyprus by Turkey 51 years ago. The military operation lasted for almost 1 month, in summer 1974. The preconditions of the Cyprus occupation are long-term, connected with different time periods of the Cyprus history, since the 16th century. Now we can proceed to the facts of the case. The applicant is Titiana Loizidou. She grew up in Kyrenia in northern Cyprus. In 1872, she married and moved to Nicosia with her husband. She claimed to be the owner of 10 plots of land in Kyrenia in northern Cyprus. She alleged that prior to the Turkish occupation of northern Cyprus on 20 July 1974, the construction of flats was commenced on her plot of land. One of the flats was intended as home for her family. Her ownership of the properties was attested by certificates of registration issued by the Cypriot Lands and Surveys Department at the moment of acquisition. Ms. Loizidou stated that she has been prevented in the past and still is prevented by Turkish forces from returning to Kyrenia and peacefully enjoying her property. In March 1989, the applicant participated in a march organized by a Women Walk Home movement. It was a women group in the village of Limbia, near the Turkish village of Akintilar in the occupied area of the northern Cyprus. The aim of the march was to assert the right of Greek Cypriot refugees to return to their homes. Leading a group of marchers, the applicant advanced up a hill toward the Church of the Holy Cross in the Turkish-occupied part of Cyprus, passing the United Nations Guard post on her way. When they reached the churchyard, they were surrounded by Turkish soldiers and prevented from moving any further. The applicant was eventually detained by members of the Turkish Cypriot police force and brought by ambulance to Nicosia. She was released around midnight and thus was detained for more than 10 hours. Turkish armed forces of more than 30,000 personnel were stationed around the occupied area of northern Cyprus. The occupied territory was constantly patrolled. The army's headquarters were in Kyrenia. The Turkish forces and all civilians entering military areas were subject to Turkish military courts under the Prohibited Military Areas Decree of 1979, Section 9, and Article 156 of the Constitution of the so-called Turkish Republic of Northern Cyprus. After the proclamation of the establishment of the so-called Republic in 1883, the United Nations Security Council adopted resolution that stated that the declaration of the Turkish Cypriot authorities of the purported secession of the part of the Republic of Cyprus as legally invalid and calls for its withdrawal. Also, there were numerous declarations of different international organizations about the illegality of the Cyprus occupation. You can see them on the screen. On 22 January 1990, the Turkish Minister for Foreign Affairs deposited the following declaration with the Secretary-General of the Council of Europe, in accordance with Article 46 of the Convention. On behalf of the Government of the Republic of Turkey, and acting in accordance with Article 46 of the Convention for the Protection of Human Rights and Fundamental Freedoms, I hereby declare as follows. the government of the Republic of Turkey, acting in accordance with Article 46 of the European Convention for the Protection of Human Rights and Fundamental Freedoms, hereby recognizes as compulsory ipso facto and without special agreement the jurisdiction of European Court of Human Rights in all matters concerning the interpretation and application of the Convention, which relate to the existence of jurisdiction within the meaning of Article 1 of the Convention, performed within boundaries of the national territory of the Republic of Turkey, and provided further that such matters have previously been examined by the Commission within power conferred upon it by Turkey. In her final submission to the court, the applicant required the court to decide and declare the violation of Article 1 of Protocol 1, the violation of Article 8 of the Convention. The Cypriot government submitted that the court has jurisdiction ratione temporis to deal with the applicant's case because Turkey's declaration under Article 46 of the Convention did not clearly exclude competence in respect of violations examined by the Commission after the Turkish declaration of 22 January 1990. Turkey is thus liable for the continuing violation complained by the applicant in the period since 28 January 1974. In any event, Turkey is liable for those violations continuing in the period since 22 January 1990, which have been examined by the Commission. There is permanent state of affairs still continuing in the Turkish occupied area, which is no violation of the applicant's rights under Article 8 of the Convention and Article 1 of the Protocol No. 1 to the Convention. In their memorial, the Turkish government made the following submission. The applicant was irreversibly deprived of her property, situated in Northern Cyprus, by an act of the government of the Turkish Republic of Northern Cyprus on 7 May 1985 at the latest. The act of deprivation of the applicant's property does not constitute an act of jurisdiction by Turkey within the meaning of Article 1 of the Convention. Turkey has not violated the rights of the applicant under Article 8 of the Convention. Now we can move on to the law. The applicant, the Cypriot government, stated that the right after the Turkish occupation of Northern Cyprus, the applicant had been denied access to her property and had consequently lost all control over it. Thus, there was a breach of Article 1 of Protocol No. 1 to the Convention, as well as continuing violation of the right to respect for her home under Article 8 of the Convention. The Turkish government contested this allegation and maintained primarily that the court lacked jurisdiction ratione temporis to examine it. The court decided to determine whether Turkey actually exercises detailed control over the policies and actions of the authorities of the so-called Republic. It is obvious from the large number of troops engaged in active duties in Northern Cyprus that her army exercised effective overall control over that part of the island. Such control, according to the relevant test, and in the circumstances of the case, entails her responsibility for the policies and the actions of the so-called Northern Cyprus. Those affected by such policies or actions, therefore, come within the jurisdiction of Turkey for the purposes of Article 1 of the Convention. Her obligation to secure to the applicant the rights and freedoms set out in the Convention therefore extends to the northern part of Cyprus. The court did not accept the characterization of the applicant's complaint as being limited to the right of freedom of movement. Article 1 of the Protocol now was applicable. With respect to the question whether Article 1 is violated, the court first recalls its finding that the applicant for purposes of this article must be regarded to have remained the legal owner of the land. However, as a consequence of the fact that the applicant has been refused access to the land since 1974, she has effectively lost all control over, as well as all possibilities to use and enjoy her property. The continuous denial of access must therefore be regarded as an interference with her right under Article 1 of Protocol 1. Such interference cannot, in the exceptional circumstances of the present case, to which the applicant and the Cypriot government have referred, be regarded as either a deprivation of property or control of use within the meaning of the first and second paragraphs of Article 1, Protocol 1. However, it clearly falls within the meaning of the first sentence of that provision, as interference with the peaceful enjoyment of possession. In this respect, the Court observes that hindrance can amount to a violation of the Convention, just like a legal impediment. Apart from passing reference to the doctrine of necessity, just a justification for the acts of the so-called Republic, and to the fact that the property rights were subject of the intercommunal talks, the Turkish government had not sought to make submission justifying the above interference with the applicant property rights which is imputable to Turkey. The applicant stated that she had grown up in Kyrenia. She had planned to live in one of the flats whose construction had begun at the time of the Turkish occupation of the northern Cyprus in 1874, but it had been impossible to complete the work. The court stated that the applicant did not have her home on the land in question. In its opinion, it would be strained the meaning of the notion home in Article 8 to extend it to comprise property on which it is planned to build a house for residential purposes. The term of home cannot be interpreted to cover an area of estate where one has grown up, and where the family has its roots but where no longer lives. Accordingly, there has been non-interference with the applicant's rights under Article 8 of the Convention. The case serves as an important precedent for judgments in international courts of law regarding the Cyprus dispute. Also, the court found that the matter of continuous denial of the applicant's access to her property located in northern Cyprus and eschewing loss of all control over it fell within the jurisdiction of Turkey for the purpose of Article 1 to the Protocol 1. The decision was attributed to a large number of Turkish troops that were stationed in North Cyprus. According to the court, it was evident from the large number of forces that Turkey exercised effective overall control over that part of Cyprus. The Bankovic versus Belgium decision is completely inconsistent with the court's approach in Loizidou versus Turkey. It is perhaps for this reason that these two cases have been considered as the most assertive cases in examining the extraterritorial application of the European Court of Human Rights. The court's dilemma and its contradictory positions have become apparent through its approach on the jurisdiction matter. At the heart of the Loizidou case lies the future of political status of a state that has unfortunately disappeared, a question to which all the international political bodies are now seeking an answer. A question of such importance can never be reduced purely and simply to the concept of the right of property, and thus settled by application of the Convention provisions which have never been intended to solve problems on this scale. Thank you for watching. Let's discuss.